in back room. So, so Article 1, bicameral legislature. Another step beyond that, a bicameral legislature was the result of the Great Compromise at the Constitutional Convention, sometimes called the Connecticut Compromise, sometimes called the Sherman Compromise for Roger Sherman, who was the head of the Connecticut delegation. We should also think of it as the Franklin Compromise, because it was Ben Franklin that brought that compromise to the attention of many delegates who found out that seemingly impossible contradiction of the small states not wanting to give up influence to the large states, and the large states not wanting to be the dog being wagged by the tail. So this was that compromise. Article 1 establishes that. Elections for the lower house will occur every other year. Members of the House must be 25 years old and have been a citizen of the United States for 7 years. They do not have to be natural born citizens, just a citizen of the United States. And they have to live in the state in which they are, and strictly speaking, you should live in the congressional district where you are running for office. The House has the sole power of impeachment. And we need to think about, well, what does that mean? Well, impeaching is not removing somebody from office. Impeachment is establishing that there are charges that are going to need to be heard by the Senate in trial and voted upon by the Senate in trial. And unless you reach a 2/3, which is now 67 senators, unless you reach that 2/3 bar, then the accused is acquitted. Now, there are no consequences of being convicted other than being kicked out of your office. And it's an entirely separate thing, as we will see when we get to Article 2, whether or not that person can run for elected a federal office ever again. You have to have one vote on convicting. You have to have a separate vote if you want them never to serve in another federal office. So two pieces to this. The Senate, Section 3, shall consist of 2 members for every state with a 6-year term of office. The Senate shall consist of 3 classes. So if you've ever noticed, we have different maps every time we get to a presidential election or a midterm election. 1/3 of the Senate is up for re-election. The idea behind that was not only that they were elected by state legislatures, which means that they were of elite status of some sort, hopefully wise, hopefully thoughtful, hopefully a lot of things almost no senators are at this point. But you didn't want to have a massive turnover in the Senate like you have in the House of Representatives every 2 years. That provides instability of policy, instability of direction, instability of wisdom. So the first Senate, when they came in, Class 1 was for 2 years, Class 2 was a term of 4 years, and Class 3 was a full term of 6 years. And that started the rotation and process that we still use to this day. Members must be 30 years old to serve. Joe Biden was elected when he was 29. So he couldn't serve in January. He had to wait till his birthday came along when he turned 30, and then he could take the oath of office. Unfortunately, between the time he was elected and the time that he was able to serve, his wife and daughter were killed in a tragic automobile accident. And he almost decided, this is too much for me. I'm not sure I can face this. And his friends said, you've worked too hard to get here. You are going to be an asset to the government of the United States. We need you, Joe. So that was the deal. And you have to be a citizen of the United States for 9 years. Now, again, we've already mentioned that the trial for impeachment, so So presidents have been impeached, nobody's been convicted. Nixon was impeached. Nixon resigned before the trial could be held because a very honest, I didn't always agree with Barry Goldwater, but a very honest Republican he was. And he went to the White House and said, Dick, you're going to get convicted in the Senate, and I'm going to be one of those that's voting to convict you. That's brave stuff. That's the stuff of backbone that we need today. So the Senate has the sole power to try impeachments. In the case, yes, Paul.
Just wondering, relative to the 6-year terms and 1/3 and everything.
Yeah.
Is it spelled out that the 2 senators from each state don't get elected in the same year, or are there any?
Yes.
Are there any states?
That's been the tradition.
Tradition, or is it actually?
I don't think, and if I go to, hold on a second here, that's why I have a pocket constitution here. Let's go to section 3. The Senate of the United States shall be composed of 2 senators from each state. For 6 years, each senator shall have 1 vote. Let's go to, immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may into 3 classes. So you had all the senators took office, and then the seats of the senators of the first class shall be vacated at the expiration of the 2nd year. The seats of the 2nd class at the expiration of the 4th year, and the 3rd class at the expiration of the 6th year. So you have a junior and senior senator from each state. Now, the way they probably differentiated at the beginning was who's the one that has the shortest term? That was probably the junior senator. The longer term would have been designated senior senator. I believe that's how that tradition got started. So if the president is being tried, has been impeached, and is in the trial in the Senate, and the rules of a normal jury trial do not necessarily apply. But in the case where the president is tried, the Chief Justice of the United States is the one that presides over the trial. But then you go, but Tom, Donald Trump, in the trial that took place in January of 2021, it was a senator that presided over that. And I said, yes, that's true, because Trump was no longer a sitting president. And John Roberts said, I ain't gonna do it. He's not the sitting president. So that's why the Chief Justice of the United States did not preside. He did preside over Trump's first impeachment trial, did not preside over the second one, and that's why. I forget what senator got the nod for being, for essentially being the judge, but that's why that happened. Each branch can punish its members for disorderly conduct and expel a member with a 2/3 vote. That's the maximum thing that either the House or the Senate can do. If they don't like how a member has behaved, that they can vote to expel, each chamber acting independently. So the Senate may not like some representative, but the Senate has no ability to expel a congressman. Lower house may not like certain senators, like Joseph McCarthy, for example, great example of a senator who is a real problem, but the House had no ability to get rid of him. And the only thing that the Senate ever did was censure him. But they should have removed him. He was a serious danger to the United States. Each House must keep a journal of the proceedings and from time to time publish it. Currently, the title is the Congressional Record. That's a wrong fact there, and I made it. They still keep journals, but the published record that we normally see is called the Congressional Record. It's not the same as the journal the Senate keeps, and it's not the same as the journal that the House keeps. And in fact, you know, our high school used to subscribe to the Congressional Record, so I go through it and I say, oh, what a brilliant speech here. No, that was probably never made in either chamber, because senators and congressmen are allowed to turn in speeches as if they gave them on the floor of the Senate or the floor of the House, and it never happened. They also have a free franking privilege so that they can send a lot of mail home on the dime of the tax-paying citizens. And Abraham Lincoln got in trouble for that. Fact is, he got in trouble for taking the long route to Washington, D.C. on the railroads. Yeah, they wanted to condemn his opponents. Politics doesn't change much. And so somebody on the Democratic side found out that the Whig, Abraham Lincoln, had added his expenses. He hadn't really, but he didn't take the shortest route there. So that was true. And Lincoln loved to send mail home. And so he took full advantage of that. The salaries and immunities of members. Okay. Of the House, the salary is $174,000 and change. The Speaker of the House is $233,000 and change. The majority and minority leaders of the House and the Senate, $193,000 and change. And the President of the United States, $400,000 exact. So that's one of the benefits that they get. They have immunity. They have immunity from needless, frivolous civil prosecution. Their speech on the floor of the House and the Senate is absolutely protected. The president might tweet at them now, but their speech by law is absolutely protected. And that is so that hopefully open and honest discussion takes place. That you're not afraid that some of your constituents, if you say something they don't like, that they're going to take you to court. Not, your language is absolutely protected. Criminal, you break the law, you can be prosecuted while you are a sitting senator or a sitting congressman or woman. There's a bar on members of either branch from concurrently holding any other federal office. So unlike the British Parliament, where many of the cabinet members are also members of Parliament, MPs, that cannot happen here. Our founding fathers did not like that idea. So if you are a congressman or a senator, that's the sole federal job you can have at that point, unless you resign your position, and then you can take another federal job like a cabinet member, which traditionally happens often.
Can you change the slide?
Oh, did I forget to change the slide?
Yeah. Oh, thanks.
Okay. Section 7. This was also a critical part of the compromise between large states and small states. That the large states didn't want, that was, I said, the tail wagging the dog, especially financially, the large states didn't want the small states wagging the dog. So all money bills must originate in the House, all of them. The Senate cannot originate a financial bill. It may add amendments, it can suggest changes, all that's fair game, but the financial bill must originate in the House of Representatives. Veto power, that's kind of a fun situation. So the president doesn't like something that's passed the House and the Senate. He was required to provide his reasons and submit the legislation back to the House and the Senate where they can adjust it to his requirements. And then he's happy and he signs it. Or they can do nothing. Or they can say, if they have a 2/3 of each chamber, they can pass it over his veto. So that's hard to do, especially in the highly polarized society in which we live today. You see Republicans voting lockstep, you see Democrats voting lockstep. And that's why. So what else can happen? Well, if the chambers adjourn and the president hasn't signed the legislation, he can stick it in his pocket and do nothing. That's called a pocket veto. So the legislation cannot become a law, even though it's been passed, even though it's been sent to the president, but they adjourned before he signed it. Tough luck. Then you have, well, what else could, and the reverse is true. Now, let's say the president puts it in his pocket and goes, nee, 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 but if that has to be less than 10 days before they adjourn, because if it's more than 10 days, then it becomes a law without his signature. You know what he didn't like about it? And sometimes presidents will use that. They know it's the right thing to do, but it isn't popular with their political party. They will allow it to become a law without their signature. Then you got one other little item that twists, and that's called a line item veto. For there was a period of time during the Clinton administration that President Clinton could go through and line out only financial things, line out financial things that he didn't like and strike them out of the bill without the approval of either chamber. Well, the Supreme Court said, sir, or actually they said to Congress, that's not in the Constitution. He does not. You want to have the president have a line item veto? There's a simple way that's not so simple, and that's called add an amendment. That's how you solve. You want that? You got to amend the Constitution. As it is written now, no line item vetoes. The powers of Congress. There are a bunch of powers. We call this whole laundry list we're going to look at very shortly. Those are the enumerated powers. Those are the powers that are directly given to Congress, no question about it. So taxes, borrowing, regulation of commerce, naturalization and bankruptcy, money, counterfeiting, post office, patents and copyrights, creating lower courts. We'll get to that when we get to the Article 3. Punishing pirates. It was a serious, piracy was a serious problem at that time, particularly the Barbary pirates. You know, if you look at the Marine hymn on the shores of Tripoli, blah, 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 blah. Well, who were those? Those were the Barbary pirates that were giving us a whole lot of trouble. Declare war. This is very controversial. And the Congress got tired of the president getting the country involved in wars without their approval. And so after the Vietnam War wound down, they passed the War Powers Act, which limits the time a president can put the armed forces in harm's way to a specified period of time, 30 to 60 days, I think. And after which point he has to go to Congress and get their approval to make sure that it limits the flexibility that a rogue president might have. To create an army and a navy. Keep in mind, these people were suspicious of standing armies and standing navies. They had not had good experiences. In the case, it's not so much that the standing navy was difficult. It's that the British would stop American ships and kidnap their sailors. It was called impressment. Yeah, they were impressed all right. And so that led the members of Congress at the Constitutional Convention to be very wary of standing armies and standing navies. The Congress can call the militia. Congress governs the District of Columbia, and the members of the District of Columbia do not like that. And in fact, a statehood for DC amendment to the Constitution was approved, but never by Congress, but never ratified. So there you go. And then the necessary and proper. So I talked about the powers that are directly given to Congress, enumerated. Well, the necessary and proper clause, let me go to this quickly. Let's see here. I'm not finding the words necessary and proper here, but they're there. And what that does is that opens the door to legislation that we call implied, that you have implied powers. Powers that everybody knows you need to carry out the powers that you're directly given, such as buying printing presses for currency, minting machines, all that type of stuff has to be done or creating post offices, for example, that are necessary to carry out the powers that you have been directly given. There's not much which are necessary and proper for the proper operation of Congress. And then the last one is inherent powers. Just because Congress is Congress, for example, how about border security? You won't find anything in the Constitution about border security or immigration or a number of other things, but that's an inherent power of Congress that they have just because they are Congress, and it's an issue that Congress would rightfully deal with. So we call those inherent powers. Restrictions on the power of Congress. A huge one, and I don't think I've got the original language in this, which would be very important because they strike oh yeah, this will work. So it says the migration or importation of such persons, AKA African-American slaves. Notice the Constitution doesn't have the word slavery in it anywhere. As if the states now existing shall think proper to admit, shall not be prohibited by the Congress prior to the year 1808. But a tax or duty may be imposed on such importation. In other words, if you are considering people property, property can be taxed. And so, and it can be different how it's taxed, and the amount could be different for each state, which it actually was. So what did that mean? That meant that Congress could not bar international slave trade. Notice it didn't say that anywhere here in the language. Couldn't bar international slave trade until January the 1st, 1808. So in 1807, Congress passed the proper legislation to go into effect on January 1808 to prohibit international slave trade. And I thought that was that. But as we'll see in just a second, no, that really wasn't that. Well, what practically did it mean for African Americans? It meant that between 1787 and 1807, 100,000 more Africans were brought from Africa to the southern colonies where slavery existed. Now, I assumed that the South ended the slave trade. In fact, international slave trade went on the whole time from 1808 right up through the end of the Civil
I
War.
heard about that. That was.
It's unknown how many thousands of slaves were brought in, but it was many thousands.
Slaves.
And only one of the captain, and the penalty was death for doing that. And the only president that signed a death penalty was Abraham Lincoln. He says, I'm sorry, but I must make an example of you. I would love to come. Your family has begged me and pleaded and wept and cried, but you were a slave trader and the consequence of that. So I'm going to give you like 2 weeks to get your emotional affairs in order, and then you shall be hung. And he was.
Good.
So what else? Habeas corpus cannot be suspended. Now, this becomes quite a bone of contention because Abraham Lincoln suspends habeas corpus initially during the Civil War. Well, isn't the power found in Article 1? Does that mean it's the power only of Congress? Yes, sir.
Can you give a brief definition of habeas?
Oh, habeas corpus translates to produce the body, in Latin, produce the body, meaning the government has to explain to you or your lawyers why you have been put in prison. So because they had lots of experiences in England of the king putting people in prison just because he didn't like them, but with no information, no evidence as to whether they had actually even committed a crime. And so they made sure. So Abraham Lincoln was desperate to keep the lines of supplies and soldiers open to the District of Columbia, which was surrounded by slave state Maryland on the north and slave state Virginia on the south. And what if slaveholding state Maryland decides to secede? The capital is isolated. So he did everything he could to make sure that Maryland didn't secede, including dropping habeas corpus and putting a few people in jail. And in fact, Justice Roger Taney, I think it's ex post Merriman, I think it is, and Lincoln ignored it. He said, well, but I've got this thing from Justice Taney, I'm to get out of jail. Good luck with that. So, and that was then, that was discussed in a Supreme Court decision after the Civil War. So that's critical. We're going to get another one. Two things you might not have heard of. What else can't they do? They can't have a bill of attainder. I used to explain to my classes like this: you're playing Monopoly. Go directly to jail. Do not pass go. Do not collect $200. Meaning that you don't get a trial. You do something, you're accused of something, and you go directly to jail. King of England loved to do that. So they said no. And in fact, in its truest sense, a bill of attainder means you're going to be executed and you don't get a trial. There's the lower levels have a different name for them, which I don't remember what it is. But since the Constitution doesn't say it, I'm not going to. Then ex post facto laws. That means making something, putting you in jail for something that was legal at the time you did it, but then a law was passed later that made it illegal, and going back and throwing you in jail, even though you didn't break the law at the time and before the law was passed. So those are prohibited. No interstate tariffs. That's because the states were squabbling with each other under the Articles of Confederation, and none of that. No preference. The states are all to be treated equally, regardless of their size. A state is a state with certain rights and responsibilities and privileges and immunities, and each state will be treated identically from that standpoint. Appropriations, okay, you've got money, you have to decide where it's going to be spent. Congress has that power, not the President of the United States. And yet this current Congress has ceded that power to the executive branch, and that's a critical mistake in my opinion. The founders had no idea. They thought that Congress would be aggressive in protecting its rights, and they could not have imagined a situation that we live in now. Also, no titles of nobility. You might want one, but you can't have it according to the Constitution. Then we get to Article 2, the office of the president. The election of the president. So we could go, I don't want to go into a lot of depth about the Electoral College, but the president is not elected by a direct popular vote. When we vote for a series of electors now that are supplied by either one or two political parties. You know, initially it was the Federalists and the Anti-Federalists. Anti-Federalists morphed into Democratic Republicans that ultimately morphed into Democrats. So the current Democratic Party is the oldest political party in the United States. You went through the other side, Federalists became National Republicans, became Whigs, became know-nothings, because when they would be asked to, you were supposed to keep what the party stood for secret. So they go, I know nothing, almost like Sergeant Schultz. I know nothing, I see nothing. And so that's how they got that.
What about the mugwumps?
Well, you have all sorts of splintered small parties like the Free Soil Party. They might do very well in one state or two states, but they never managed to get any type of majority. So they existed, so you have the ability to have a third or fourth or fifth party, but in a winner-take-all system, which is what we live in, they cannot generate enough support to be the actual winner in an election with multiple parties. So that's why we have two major political parties, and that's our Achilles heel. And keep in mind, the founding fathers you won't find a word about political parties in the Constitution. They didn't imagine them. They did understand factions. And factions are what actually became political parties. And they talk about factions in the Federalist Papers, but not in the Constitution. Requirements of the president: natural born citizen, unless you were a citizen at the time the Constitution was ratified. So anybody up to that point of ratification qualified. So Hamilton was born offshore. In the Azores, I think, Haiti, Dominican Republic, something like that. He wouldn't have qualified. But he was a citizen of the colonies at that time, so he would have qualified. Today, he wouldn't. That doesn't mean you have to be born in the United States, because you can be born on a military base, which is considered Ramstein Air Base in Germany, as considered American soil. So if you're born there, you are considered a natural born citizen. And you must have had residency of 14 years. That 14 years doesn't have to be contiguous, and it doesn't have to be just before you run for office that you have to have completed 14 years. You just need 14 years total. Pay of the president, $400,000. The powers of the president: he's the commander in chief. We like the idea of a civilian in charge of the military, which is not to say that we haven't had a good number of generals, starting with General George Washington, okay, who without whom we wouldn't have any of this anyway. So, and George Washington is the only one that actually physically led an army onto the field. And that was for the Whiskey Rebellion in Western Pennsylvania. And basically those in rebellion said, Washington's coming. They didn't like to offend George Washington. That meant a lot. So basically, because George Washington was leading this army, the Whiskey Rebellion just melted away. Lots of them went to Ohio, some to Canada, but yeah.
That was while he was president?
Yes, yeah.
Oh.
Yeah, 1793 or 94, yeah. And so here, they got through Shays's rebellion, which was over taxes, and this was over duties on whiskey, whiskey was almost money. It was literally used as money to exchange. It was very valuable, and they hated to pay taxes on it. Impeachment and or conviction for treason. So what are the things that can get you impeached? Oh, good. Treason, bribery, and other high crimes and misdemeanors. So, and it's defined so poorly that did Bill Clinton, by having sex with that, I didn't have sex with that woman or that woman, maybe that woman, lying under oath, did that qualify as a misdemeanor? I thought it was pretty frivolous. Not that I was not unhappy with Bill Clinton, because I was very unhappy with Bill Clinton, because you squandered an opportunity to be a great president. So there we go. But those are the things that are that can make you eligible for impeachment. Article 3, the federal courts. Actually, in the Constitution, I should say the federal court, because only one court is described, and that's the Supreme Court. It's left up to Congress to provide the courts that sit underneath it. So initially, there were 6 justices on the Supreme Court. Every one of them had a district in which they were the presiding judge. That was called going out on the circuit. So every Supreme Court justice not only would sit occasionally as the Supreme Court, but they also took care of all the federal cases at the same time. Ultimately, over the years, you got more, and it was left up to Congress to create the courts that sit underneath it and to determine what's jurisdiction, what is it you can actually rule upon. And so it's quite clear from Federalist 78 that Alexander Hamilton said, well, good golly, Miss Molly, who else is going to rule on the constitutionality of laws but the highest law court in the United States? It makes sense. That's called judicial review, by the way, determining whether laws are unconstitutional or constitutional. Over time, then, so they put the district courts, of which we now have 93. Then above that are 13 sets of courts of appeal, which the map is like this. So 13 districts, and Washington is in the liberal District 9, and that includes Oregon, Washington, California, Nevada, Arizona, Idaho, and Wyoming. Montana, sorry. So, and the 11th Circuit Court is Mississippi, Georgia, and Florida. It's a conservative district. So that's why, or Texas is also super conservative. Texas, Louisiana, it's Mississippi is in 5. That's Alabama and Georgia that's in District 11. So it's called judge shopping. So you try to find a court that's sympathetic to your particular viewpoint and will likely rule the way you want. And then when 2 different district courts of appeals rule in different ways, that's when you're assured that it's going to go to supposedly the umpire, which is the Supreme Court of the United States, if they choose to hear it. And if, I do believe
It died?
our batteries
No,
are,
we're-
okay.
we're good.
I'm not sure, maybe I pressed the button.
Maybe.
Now I lost my train of thought, got derailed here. Okay, so,
Judge shop, Supreme.
judge shopping, right. And so that's a real problem because you would hope all of the districts would rule fairly on the basis of the laws. And that doesn't always, it's clear that it doesn't happen. Some judges are much better than other judges. So, and treason. Treason is defined in section 3. Let's pick that up here. And treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. And that's why Aaron Burr wasn't convicted of treason, because they couldn't find any more than 1 witness. So he escaped. What he did was certainly treasonous. Then we get to Article 4, which is all about our states. Full faith and credit, which means that states have to respect the laws of other states. So maybe West Virginia, you can get a driver's license at 15, in Ohio it would be 16. But the West Virginia driver's license is valid in Ohio and any other state in the United States. Full faith and credit became very controversial with gay marriage because some states allowed it. Like Vermont was a pioneer, Hawaii, I think, was a pioneer, and other states resented that. So Congress passed the Defense of Marriage Act, which was a bunch of baloney. And essentially, it violated the Constitution because the Constitution is clear. You must abide, even if you don't agree with them and don't like them, that marriage is valid in your state, at least while they're visiting. If they become permanent residents, that's a whole different ballgame. But normally speaking, that should be the end of it. And then you have privileges and immunities. So essentially, what privileges and immunities means is that one state can't discriminate against citizens of another state. So if you're a lawyer in Pennsylvania, you can practice law in Ohio. You might have to buy a license or something like that, but you have the skill set to do it. Well, what about colleges charging more for out of state? Well, that's different. The student can still go to your college, they're just going to have to pay more for it because they haven't provided any of the tax money that gives the lower fees. So that's how that's justified. So that's privileges and immunities. Extradition. If somebody has committed a crime in one state, now you've got to be careful because you've got the governor of Texas who's trying to round up Democrats. The Democrats didn't break any law in fleeing the capital to prevent redistricting from occurring. But, so the governor, Pritzker, the governor of Illinois, is basically going to go, and come and get them. And literally Texas can't do that. So now, if a crime has taken place, an actual crime, and the person has fled one state, then that state's governor can request that the criminal be brought back via extradition. That's completely legitimate. And what about governing territories? Well, the Congress has an obligation to provide a Republican form of government. And in making new states, you cannot subdivide an existing state without its permission. And that has been, so Tennessee was part of North Carolina. Kentucky was part of Virginia. Alabama, Mississippi were part of Georgia, claimed by Georgia. Maine was part of Massachusetts. And West Virginia was part of Virginia. And that's the exception where probably allowing West Virginia to become a state because there was what was called the Rump legislature, which submitted that met not in Richmond because that was the real legislature of the state of Virginia, but in Wheeling, West Virginia. And so that legislature said, we agree that you can split up Virginia into West Virginia and take it away from Virginia. Lincoln was troubled by that, but he said, oh, what the heck, it's a civil war. If we lose, Virginia gets it back anyway. So he went ahead with it. So Article 5, amending the Constitution, 4 methods. 2/3 of both houses of Congress approve, sent to 3/4 of state legislatures where it's ratified. Or 2/3 of both houses of Congress send to 3/4 of state ratification conventions. Only one has been done that way. And that was the 21st that repealed the 18th on prohibition. The people wanted to drink. So that rolled through. Or 2/3 of state legislatures call for a convention and 3/4 of the legislatures ratify. Or 2/3 of state legislatures call for a new convention and 3/4 of state conventions ratify. Article 6, we're coming down we're gonna make it. The assumption of the debts of the Confederation, talked about that. The Constitution and federal, this is the critical one. The Constitution's the supreme law of the land. And no religious test to hold office. And that will be reiterated by the First Amendment to the Constitution, first of the Bill of Rights. And then ratification. Ratification by 9 states is sufficient to establish the Constitution. So, that in a nutshell, as fast as I can go, is an explanation of the 7 articles of the Constitution. And I will now open to questions. And if there are questions, Zoom questions, George, I will depend on you to let me know. First name, please.
Leah,
Leah.
yes. My question has 2 parts.
Okay.
One, you mentioned the members of the 2 houses have immunity and say whatever they want.
Yes.
So how does the President of the United States
Leah,
sue
What?
people?
Leah,
for saying things.
Because it's a frivolous suit and it isn't gonna go
Who-
anywhere and everybody
Person's name
knows it.
is that Arlia? Probably
Well,
not.
that's because they didn't have the backbone to stand up to
This
it.
has been sent out all over.
Doesn't really have the legal right to do that.
No, he doesn't.
Doesn't
And
sound
they
like.
should know that. And that's how they should respond. Go ahead and sue me.
I mean,
And
I
let's
don't
see how well
know
you,
How he can collect as an individual citizen when he's the president.
he really isn't, that's called the emoluments clause. He really isn't supposed to do that either.
And this-
We didn't go into the emoluments clause, but he has violated that left, right, and every
the
which
second
direction.
Question is, has any president before Trump ever pulled that?
No.
Yeah.
Yes, sir.
First of all, is,
I'm gonna raise our
be
hands.
on the floor of the House to say these things?
You have to turn up your volume. My volume's up all the way.
Technically, yes.
So they
She's
have
supposed
to
to
be-
Yeah, this is as part of their role of being in Congress, arguing, debating, yeah, which I left one thing out on the Senate. Only the Senate has the right of filibuster, the right of unlimited debate. Yes,
See,
sir.
people online faster there.
This Constitution is ratified. It's my understanding that several newspapers that they printed the Constitution in the.
Yes.
But how did the people know ultimately what was in the Constitution?
Well, a lot of them tended to be very good readers. And then you had, especially in the state of New York, you had Alexander Hamilton and James Madison publishing the Federalist Papers, which were discussing, it's the best explanation for how our government was intended to act and behave and function. And so you had that, and Hamilton actually published that in book form in 2 volumes. But people were writing left and right. They were all writing to newspapers. The anti-federalists were writing, the federalists were writing. It's just the federalists were a lot more prepared and skilled in their debates than the,
Constitution itself would be printed and would be in public office.
absolutely,
Ultimately in
yes.
schools and things like that.
Yes, it was widely distributed. Yes, sir.
Interesting comparison, the Soviet Union broke itself apart. We have a bigger and bigger and bigger country that doesn't seem to want to, quote, be united.
Right.
Doesn't the Constitution say nothing against secession? You can just go ahead and break apart?
No, you can't.
Where does it say it in there?
Basically, in talking about the states, it says they cannot form a treaty, they cannot form a confederation, which is exactly what the South tried to do. That's prohibited. And Abraham Lincoln's argument was, well, take a look at the Articles of Confederation and eternal union. He said they already had agreed to that before they transitioned to the Constitution. Therefore, states do not have the right to secede.
But did they really believe that a 400 million people country was, quote, manageable?
They thought that James Madison's argument was that because it was physically a large country and with many people in it, you wouldn't have dangerous majority factions able to form. But of course, he had no idea about lightning communications and the ability of people to be persuaded by untruthful arguments.
I'm saying,
It-
it seems like it's something.
It depends, again, it goes back to the edge, as Ben Franklin said, a republic, madame, if you can keep it. And that hinges upon an educated and enlightened and thoughtful, responsible public. So some of this is on us.
One last question on that.
Yeah.
Can you make a law in a congressional level that jury duty and voting duty are the same and you have to vote?
Since states control elections, I think you're on thin ice.
But this is a state, we could do it in this state. but-
Yes,
The library
absolutely.
is now closed and will reopen Friday at 9 AM.
But just,
Have a great
if you
weekend.
don't want to vote, pay the fee. Yeah.
Well, there is something to that, like what Australia does. You get fined if you don't vote. That'd get a lot of people out. But other than that, there are practical things we could do. We could make elections a lot easier. There's a hand up? Okay, we could make elections easier and convenient. We put it on Tuesday, it's a work day. Lots of people need to work, they can't get out and vote. And now when we come up with these great ideas of mail-in voting, which I think is a superb idea, but then you look at what percentage just voted in the primary, that was easy. Yeah, I had 2 people I could choose, that was it. And stick it in the mailbox, don't even have to put a stamp on it, and I think it was 18%. Yeah,
So, regarding the pocket veto.
Yes.
If a bill is passed but not signed by the president, can it then be signed when Congress resumes after break?
no. If you have, it's that 10-day limit after I think I'm gonna stay with no. I think once Congress adjourns, then the president is in the driver's seat on that. Basically, what you can do is start over. That's the way it's normally done. You reintroduce it, go through the whole thing all over again, and this time make sure you get it done before adjournment. Yes, David.
My question was also about the vetoes. I was looking at an online list of all the vetoes historically. And the great majority of vetoes in the past were pocket veto.
Yeah.
But in the recent administration, there's almost no pocket vetoes, or almost all.
That's because he's not vetoing anything.
Well, the few vetoes there are though.
Yeah.
No more pocket, well, Trump has.
Well, he cannot, he does not have either house where he has a veto-proof majority. It's razor thin in both houses, so he'll never get to 2/3.
But I'm talking about with like under Biden, what vetoes he had, he said he signed with the pen.
Yeah.
And Barack Obama before him, if there's some kind of change that where they feel the need.
We are outside the norms in almost every respect. And I don't have great answers for that. George?
Another one from Donna. If Congress forbids bills of attainder, why isn't that being used as a defense for what is happening with ICE?
Because ICE is breaking the law. That's the simplest explanation I give. ICE is a modern version of the Ku Klux Klan. Instead of white hoods, it's black face masks. Instead of white robes, it's military garb. They are a modern incarnation of the Ku Klux Klan. Yes, Paul.
2 things. I heard you mention the upper house and the lower house of Congress.
Yes.
And I just want to say, I was at Liberty Hall in Philadelphia, and we've always been led to believe, oh, the upper house, so much more deliberative and higher and blah, blah, blah.
They
And
are.
it's not. It's
Yeah.
there were more representatives than there were senators, and the representatives said, you guys take the stairs.
Yeah, and that would be fine. And don't keep in mind that by deliberative, we had Congressman Preston Brooks that beat the crap out of Senator Charles Sumner, nearly killed him. And I read at one point, prior to the Civil War, there was a point where 50 members of the House pulled their guns out during one contentious debate. It's a miracle that there wasn't a shootout at the OK Corral.
Now, I have a question relative to the secession business.
Right.
I've heard people from Texas who always, they're the only people in the country that.
They have a legitimate
Do they
possibility.
really?
They were their own independent republic before they agreed to be part of the United States. They're the one and only one that I think has a teeny sliver of basis to say, if we voluntarily joined, we can voluntarily leave. They may be right about that. I don't think so. I think this was a one-way door. Once you went through that door and it closed, you are part of the United States, end of discussion. But you know how it goes in Texas.
Well, it's the only state I've ever seen where you meet somebody from there and they say, hi, I'm Bob, and I'm from Texas. Very proud of themselves.
Any other questions on this, on the Zoom session there, George?
Not right now.
Okay,
I have
David.
a question right back to the beginning, not exactly constitutional, but if we, the people of the United States of America,
Right.
I've wondered before, does anyone know when that term was first used, the United States? It's a very powerful term.
Right about the time the Constitution, because the Articles of Confederation did not, I forget how it worded it, but it wasn't like the United States. And Shelby Foote, who is a historian that I used to admire, but now that I realize he really pulled one over on Ken Burns, had a statement where he says, before the Civil War, it's the United States are. After the Civil War, it became the United States is. A single entity, yeah. But there are all sorts of other things that he schnookered Ken Burns badly on the issue of, for example, that Nathan Bedford Forrest was one of two geniuses and Lincoln was the other. I wouldn't be promoting the racist Nathan Bedford Forrest anywhere as any type of heroic character. He was a very talented soldier, but that's it. He was a bad human being. Not anywhere close to the class of Lincoln. Yes,
So you mentioned that guy Gouverneur.
Gouverneur Morris, yes.
What is the background of his name, which was interesting. But I didn't quite get closure on the list of states versus the United States.
Because
And
it says who is the federal government actually interacting with? With we the people, it's your citizens directly, no matter what state they're in. If you listed the states, now it's the states are an intermediate level, and it's the states that are interacting with the national government, not the people directly. That's the key.
And so he brought that up and convinced people.
Gouverneur Morris deliberately did that. He struck the states out. It was there. It was going to read almost identically to the Articles of Confederation. He says, no. We are dealing directly with our citizens. We the people.
That's why, that's what caught me, that the United States of America, we may have failed to form a real national identity without that line.
I think so.
Yeah.
Yeah, it's critical.
So is that arguably the most important phrase in the whole Constitution?
I think so. Without that, the rest of it might not matter. And people wouldn't have bought into it. Yes,
I have one request here. Could you please repeat questions for people on Zoom?
okay.
They can't quite hear the questions being. asked.
Sorry, folks.
Question.
We should probably have like a second microphone or something.
Yes. And one that doesn't turn itself off automatically, which this one just did again. Yes, my better half, Georgia.
On a case of, they can't suspend the privileges, the writ of habeas corpus. But it says unless when in cases of rebellion or
Right.
invasion, the public safety may require it.
And that's exactly it's Micah story. That's exactly what Lincoln did. Even though it's in Article 1, which normally means the legislative branch, the legislature was not in session. And so here we have this, effectively an insurrection. I have to deal with it. So I'm taking that on. Congress approved. When he brought them into special session in July of 1861, they backed him up and said, we agree that you needed to do that.
But isn't that how
What Trump is trying to do.
regime legitimizes
It can.
the ICE? Yeah,
Yeah.
he declared a national emergency.
Right, that's the danger, right? But you should have brilliant, thoughtful congressmen, and we've elected a bunch of wackadoodles.
Isn't it true that the largest political party is those that don't vote?
Yes, independents actually are now larger than either of the two political parties. And by the way, you gerrymander districts, they are cut out of the deal. And so that's one of the reasons why our voting percentages are so low, is because independents aren't identifying with either political party. and they have no mechanism. So what should happen is that every state, which they won't do, should adopt a policy where anybody can vote in either party's primary. And that resolves that issue.
Don't we have open primaries?
Some states do. It all depends on the state you're in because they don't have to be identical. Ohio is an open primary. I don't know about Washington. Okay. But some are closed primaries. You must be a registered party member, and that's the ballot that you can use in a primary. But it drives you towards eccentric candidates who are ideologically pure, so to speak.
Why an open primary with ranked choice voting?
That's complicated, and most people have no understanding of what it is, but that's a good way to handle it. That's one effective way.
Requires an educated public.
Yeah, once again, we keep coming back to that educated public.
Which is why they're getting rid of that Department of Education.
Yep.
Isn't that what we have in Washington? We have the top two. That you.
We don't actually have a ranked choice, but
I thought we could have, like, you could be voting for two Republicans if those got the top and.
I'll have to look into that.
We had that last year with Commissioner of Public Lands,
Okay.
where it was very, very close to having two Republicans on the ballot in
Mhm.
the fall.
Right, ranked choice is where you specify your choice.
Yeah.
By rank. This is my first choice.
This is my second choice, this is my
third
third choice, which we do not get the opportunity to do that in Washington. But it's very effective in calling out people that don't matter. Any other questions? Well, thank you for hanging in there. I went through a lot very quickly, and it's a lot to digest. So thank you for your attention and your very thoughtful questions. There are times when I agree with you on that. So, one last thing. Yes.
When's our next one?
That's what I was just going to say. Last session, which we're going to do, creating the Bill of Rights and looking at some of the important amendments. That will be September the 8th, which is a Monday at 6 o'clock. So thank you for coming tonight. Okay. Say again? Okay, so take care, everybody. It's still light out. Ain't Washington wonderful? Fire away.
When did you decide that there's two separate ballots?
Right.
You're supposed to be separate.
Right.
When did you decide that the Senate?
You got hit by a.
That was part of the sharing of power between the executive and the legislature. And they thought, well, the Senate is the wiser, supposedly wiser group. And they, because they had to approve any change the president made, and that was within the Senate nominations.
They don't say,
The wiser body.
Okay, but that's not part
And
of
if you're about to move a chair.
Well, it does say, these things.
That's what I thought. Leave it. But I wanted to talk.